1, DT.06.08.2026.
First appeal might have filed.
It is not the first appeal, bail is in second.
Second. Item 1.
He's 13 years.
Informant consent is a hearsay witness. Allegation is that 3 persons from the village, out of which there are 2 petitioners also, they are also named Ranjit Kumarochi. It is stated that
Video has been circulated.
so that is the allegation.
So investigation is still going on, madam. We do not know. They will take time to collect the videos.
Case diary will be called for.
So why case diary?
No, so
Investigation
statement of the victim-
charge sheet has been submitted. What purpose will be served by calling the case diary? Investigation is still on.
Statement of the victim will kindly be considered. If she has exaggerated a motion stating there was another vote stating that one Ranjan Kumar was also there.
So
Just to verify that motion, which Ranjan
that
Kumar
doesn't
has
make any difference. There is an allegation
No,
against
she
you.
has not stated that Ranjan Kumar was present at the
It is not relevant at this stage. Not at all relevant.
Petitioner number 2 is a labor and petitioner number 1 is a student himself.
Not at this stage, madam. At the stage of investigation at this time, no.
Notification has also not been
VA number 6862 of 2026.
Kindly
Or the
consider
learned
case
counsels appearing, no, not required. Or the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioners are in custody since 11/5/2026. And they have been falsely implicated in this case. The learned counsel for the state has opposed a prayer for bail and has submitted that investigation is still going on and there is an allegation, there is direct allegation against the petitioner, and it has also been alleged that on social media platform, Instagram and Facebook, the video has been made, uploaded and made viral. Considering the fact that investigation is still going on and there is direct allegation against the petitioner, this court is not inclined to enlarge the petition on bail.
Observation may be given because the petitioner number 1 is a student matter.
You should take care, at least you should wait for the investigation to complete. ये कैसे वायरल फोटोग्राफ है, कहाँ से आप इतना इनिशियल स्टेज में नहीं हो सकता.
Item 2, BA 7021 of 2026.
Similar case में case diary मांगते हैं. अगर कोई उसका case diary.
Close this case on 11th of August 26 along with DA number 6582 of 2026. The learned counsel for the charge sheet नहीं हुआ लेकिन साथ में है देखते हैं. चार्ज शीट नहीं हुआ है तो हम बेल नहीं देंगे, आपको बता दें.
दोनों सेम डे अरेस्ट हुए थे.
इसलिए तो आप बोले हैं कि चार्ज शीट हुआ है कि नहीं.
आपका वेरीफाई करने के लिए बोले थे.
हाँ तो क्या हुआ?
तो ऑर्डर लिखा है तो ऑर्डर में कई जाने मांगा गया तो हम फोन लगाए नहीं.
नहीं बात होती ना आपकी, बस बहुत अच्छी बात है. अगर आप हमको सही इंफॉर्मेशन 11 तारीख को नहीं देंगे ना तो हम आपको सब
जी हम वीडियो कर लेंगे उसी दिन वीडियो को. अगर उस दिन नहीं 50 से आया हम तुरंत वीडियो कर. अब कल भी केस लगा हुआ हम सिंपल वीडियो कर लेंगे. ऐसा रहेगा. हम नेट से निकालेंगे.
हमको नहीं पता, हम नहीं जानते वाला स्टेटमेंट ना हमको पसंद नहीं आता. केस फाइल करते हैं तो आप पैरिकार से
पैरिकार नहीं बता पाए ना. नहीं पता.
नेट में नहीं पता
हम
चलता
जो
है.
भी मैम के सामने
नेट में स्टेटस केस का पता चलता
हम
है.
चेक करते खाली एंटी से जो डिसमिस होता वही आता. हम उसके आगे हम जानते भी नहीं है.
जानते नहीं है तो भाई अपने फ्रेंड लोग से सीखिए. वो देखिए वो राहुल जी उनको पता है कैसे चेक करते. आपको पता है ना कैसे चेक करते हैं स्टेटस ऑफ द केस.
हमने चेक कर.
हैव सम ट्रेनिंग प्लीज. बच्चा लोग से ट्रेनिंग लेने का.
आप लेना
हम भी ले लें.
हम भी लेंगे वो.
हाँ तो लीजिए ट्रेनिंग लीजिए. स्टेटस के लिए आपको किसी पैरिकार का जरूरत नहीं है. नेट में सब चीज का स्टेटस मिलता है. देखिए उन सबको पता है जितने यहाँ बैठे हैं ना.
नहीं पता.
They are next generation. They all know.
खाली ई कोड खोलते हैं और उसका केस नंबर डालते हैं तो उसका जो स्टेटस बताता है कि डिस्पोजल हो गया है, सेपरेटली भेल ही सब।
ऐसा नहीं है। Council for the state is directed to ये वाला antecedent बता दें, contract file कर दें, antecedent is directed to file counter affidavit stating whether any victim has been identified in the present case and also produce a case diary and also produce a criminal antecedent report of the petitioner indicating as to whether any case has been registered against the petitioner / in connection with the mobile or SIM recovered from the possession of the petitioner in the state of Jharkhand or in any other state depending upon the materials collected and the crime news. If the charge sheet is submitted by the next date, up-to-date case diary we also produce before the court by the state. Charge sheet हो जाता है तो आप case diary produce करो. Tag the budget.
Permission item 3, DS.06.08 of 2026.
In this case, last occasion, statement of victim has been called for now.
क्या बोलना है?
ये तो
She has said कि खुद ही चली गई थी शादी की तरफ.
अरेस्ट तो हुए साथ में इवेंट में, अरेस्ट के साथ में इवेंट हुई रेलवे स्टेशन.
She is just 14 years.
14 years कंसेंट तो
Consent तो क्या बहुत ही एकदम ही बच्ची है. आपका कितना उम्र है? The counsel for the charge sheet हो गया ना? Counsel for the petitioner submits that petitioner is 18 years. Is in custody since
12/2/26.
12/2/2026. Any antecedent?
No accident.
Having no criminal antecedent. He submits that the statement of the victim recorded under section 183 BNSS was called for from the concerned court. And as per the statement, the petitioner and the victim were known to each other for last 3 years and were having love relationship. And she herself eloped with the petitioner. And they got married. No force was applied to her by the petitioner. The learned counsel for the state, while opposing the prayer campaign, has submitted that the victim is minor. After hearing the learned counsel for the parties and considering the statement of the victim recorded under section 183 BNSS, and the fact that charge sheet has been submitted, the petitioner is directed to be executed.
From daily list for orders beautified item 1, DA filing number 7905 of 2026.
Petitioner absent. However, time till 14th August is granted to the petitioner to remove the surviving defense. If the defense are removed within time, post this case and appropriate hearing on 18th of August.
For the Saturn 2, DA file number 16858.1026.
It is a scheduled up with maybe with liberty to legislation. It will be terminated. Bonded under section of the Bonded Labor Abolition Act.
Bonded labor में तो
TMLA. Yes, TMLA.
the learned counsel for the petitioner seeks permission to withdraw his bail application to avail his remedy as per law. Following his bail application is dismissed as not pressed. Also for the
Sign
state, no objection to the
For press filing item 3, DA 6332 of 1026.
state of trial. Sorry? Stage of trial. Stage of trial is for 3 witnesses have been examined on 23/4/26.
Out of yours.
And I'm in custody since 26/8/25 years. 11 months. No, 11 months. And I have
Any antecedent?
no criminal history because I have stated just in paragraph 32. These are 18 minutes. Yes. 18 minutes of that is page paragraph 75. Amount of rupees 47,597.
Is it a case of organized crime?
No, that's more
111 is also there.
it is there, but there is nothing to show that that in the case of organized crime, you have to know other breakings, there is an enlarged brain use by the pertinent bench of this witness. And on the bail application already been refused by your lawyer because
Charge was framed only on 13/3/26.
yes, miss.
And on
5 months.
23/4/26, 3 charged witnesses have been examined.
Yes, miss. I'm in custody for more than 11 months, miss. More than 11 months.
Who has been enlarged on bail?
That's about the question you granted me Khogin Da, he has been granted by the pertinent bench of this honorable court.
Who has been granted?
Khogin Da, and one of the bail application have already been refused by your lordship for minutes. That there is a transaction of more than 61 lakhs, so that this is the only reason of rejection minutes. But so far as this petition is concerned, there is a transaction of 47,597, and he has no criminal history minutes.
Where is the earlier rejection on?
That is connection 2, page 38.
This Govindan has not been appearing before the court. As per the order sheet, he is absenting on number of days. That is also an impediment in the progress of the. He has been absenting in a few days. On few days he has been absent. You've heard the learned counsel's appearing on behalf of the parties. The counsel for the petitioner submits that the petitioner is in custody since 26/8/2025. And his bail application was rejected earlier on 17th of February 2026 in DA number 10615 of 2025. The learned counsel for the petitioner submits that. At the time the improved order was passed, 9/10 का improved order आपका time है. The learned counsel submits that the petitioner has renewed his prayer for bail only on account of custody. has further submitted that the charge was framed on 13/3/26 and there is no much progress in the crime and only 3 witnesses out of 10 were examined on 23/4/2026. And thereafter, on numerous dates, the witnesses have not been produced by the prosecution. To further submit that the petitioner has no criminal antecedent. And one mobile, one SIM,
No, two mobile, three SIMs.
two mobile, 3 SIMs were recovered from his possession. And one victim has been identified. The learned counsel submits that. Where is the orders of co-accused? इसका ये रिजेक्टेड है, बाकी को accused का ही बोल रहे हैं, एक का रिजेक्ट हुआ, एक का हुआ, एक का रिजेक्टेड, किसका हुआ?
Okay. But his case is on different footing.
एक का जिसका रिजेक्ट हुआ उसका ऑर्डर का कॉपी नहीं है.
Rohit Mandal's bail application has been refused by you also. So there's a
The learned
direct
counsel
application.
submits that. उस बुद्धि का एक खलील So accused namely Hogen Dan has been enlarged on bail by 400 bench of his court on 8/12/2025. And the bail application of another co-accused named
Rohit Mandal.
Rohit Mandal has been rejected by this court. The learned counsel for the state, while opposing the prayer for bail, has submitted that charge has been framed only on 13/3/2026 and trial is in progress. Inasmuch as 3 witnesses have been examined on 23/4/2026. After hearing the learned counsel for the parties and considering the fact that the bail application of the petitioner was rejected on minutes earlier. And trial is in progress. This court is not inclined to enlarge the petitioner on bail. However, the petitioner may renew his prayer for bail after 3 months.
Item 4, DA 7035 of 2026. Item 5, DA 7036 of 2026.
May I please approach? If offense under section 302, 201 and 120 of the Indian Penal Code. In this case, there is no eyewitness to the occurrence. There is general and vague allegations in the FIR that there has been some dispute between the informant's mother, who is the deceased, and the co-accused persons. And later on, she has been,
It's a case of witchcraft.
yes,
Her throat has been
slit,
slit.
yes. One of
3
the,
out of 12 witnesses have been examined.
yes,
What is the present stage?
one of the, is the same. One of the co-accused
And
has
all
been
of them have
granted.
supported all the witnesses who have examined have supported the case.
No,
This is what has been mentioned.
not I'll show you, Lordship.
Where is
One
the,
of the co-accused has been granted bail by your Lordship.
we come to that later.
Yes,
Who has not supported the case?
your Lordship may come to the deposition, which is at page 21.
Yes.
She is the informant of the case. Your Lordship may kindly have produced at page 23. मैं इस घटना को घटते हुए नहीं देखी हूँ। मैं
She
याद
is not the eyewitness. She is the
She is
informant.
the informant.
She is not the eyewitness of the case.
Yes, there is no eyewitness.
Maybe there is no eyewitness, but the incident has happened. It's a very, very serious incident.
Yours, the incident has happened, yours.
There is no doubt on that.
No doubt. But yours, the whole incident and the FIR, if your lordship will see, whole allegation of assault or Miller's previous enmity has been casted upon Joto team, and who has been granted bail.
No.
इन्हीं के ऊपर सब जगह है कि इनसे लड़ाई हुआ, ये विच ड्राफ्ट के बारे में बोलते थे।
आपके कन्फेशन स्टेटमेंट पे रिकवरी,
यस,
उनके कन्फेशन स्टेटमेंट में रिकवरी
नहीं,
इसीलिए उनको पे
यस, Lordship may come to the deposition, Milords.
No, we will not.
Yes, Milord.
We will not
Milords,
appreciate the deposition.
Milords, let me place my argument. My recovery is shown from the Caesar list, Milords, and the Caesar list witness have been examined. Your Lordship may kindly have a look at page number 24. Who is the Caesar list witness?
He is the only witness.
No, two witnesses.
Both of them have been.
Both depositions have been annexed.
They are hostile.
Yes, no, Milord. Your Lordship may kindly see. मैं इस घटना को घटते हुए नहीं देखा था। आज न्यायालय में जो बयान दिया हूँ वो घटना के बारे में सुना था, वही बताया हूँ। जिस जब्ती सूची पर मैंने हस्ताक्षर किया था, पुलिस के कहने पर हस्ताक्षर किया था। एंड सेकंड पेज 26 मिनट, ऐसी बात नहीं है कि पुलिस के समक्ष दिए गए बयान में मैंने बतलाई थी कि दिनांक 6 को सुबह 6 बजे मैंने सुना था कि मुन्ना सामंत, शंकर सामंत, महेश सामंत, राम सामंत, जोटो क्यूब ने मिलकर नवासी कोई की हत्या किया था। मैंने घटना घटते हुए नहीं देखा। जिस जब्ती सूची पर मैंने हस्ताक्षर की थी उसे पढ़ सुनाया नहीं गया था, केवल हस्ताक्षर करने के लिए बोला गया था।
Or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since
21/6/2023.
21/6/2023, and there is no eyewitness to the alleged occurrence. He submits that though the allegations in the FIR are very serious and the throat of the deceased was slit open, but the petition has been falsely implicated in this case. He submits that the co-accused, namely Jotu Tube, has been enlarged on bail by this court in BA number 5049 of 2026 by the order dated 14/7/2026. He has further submitted that there is an allegation that the murder weapon was recovered on the confession statement of the petitioner, and he has confessed his guilt. But the Caesar witnesses have been examined, and one of them has been declared hostile, and they have not, and the other Caesar witness has not fully supported the prosecution. The learned counsel for the state has proposed a prayer for bail and has submitted that there are serious allegations against the petitioner, and so far as the bail of the co-accused is concerned, there was no recovery on the basis of his statement, and there was recovery on the basis of the confession statement of the petitioner. The trial is going on. Out of 12 charge sheet witnesses, 3 have already been examined till 25/6/2026. After hearing the learned counsel for the parties and considering the seriousness of offence and that the trial is going on. And it is alleged that on the basis of confession statement of the petitioner, the murder weapon was also recovered. The petitioner, are you named in the FIR?
Yes, ma'am.
The petitioner is also a named accused in the FIR. This court is not inclined to enlarge the petitioner on bail. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. कोई FSL है इसमें? Counsel for the state is directed to communicate this order to the Director Prosecution and also to the SP of the concerned district. The aforesaid authorities shall take due care that the trial is not lingered on account of any omission on their part, as the petitioner is in custody since 21/6/2023. आप देख रहे हैं कोई उसका स्टेटस नहीं है। 14/7 को ये फाइल हुआ है और ये 20/7 को फाइल हुआ। 14/7 का ऑर्डर है, 20/7 को फाइल है, लेकिन कोई उसका स्टेटस मेरी फाइल में नहीं रहता। नहीं, ऐसा नहीं चलता। The office is directed to explain as to why the status of the co-accused as to why the order of the bail order of the co-accused has not been placed. What did you ask? Then, take it from.
Item 6 BA 7037 of 2026.
There is worship, general and omnibus allegation against the petitioner, your worship. There is no allegation of any overt act on this.
इन दोनों का bail order का BA order निकल BA number 646
One
of
of the
26.
cases has been granted bail and
I know, that is why I'm asking. BA number 6463 of 26. And BA number 6407 of 26. शायद ही upload नहीं हुआ। एक का allowed है, एक का rejected। Correct? 6407 देखिए। संतोष साहु को इसलिए बेल दिया था because there is no overt act.
on the
He was
instance of
simply there, and allegation is that at his instance it was done. What about you?
worship, there is allegation upon several persons, your worship. दो गुटों के बीच का झगड़ा था, उसमें एक गिर गई,
गिर के नहीं डेथ हुआ
Your
मैडम।
worship, झगड़ा
Cause
में-
of death is
मारपीट,
पूरा उनका
हार्ट फ्रैक्चर से
हार्ट रप्चर हो गया। तो ये कोई गिर के नहीं हुआ है डेथ। एवरीबॉडी क्लाइंब ऑन
हाँ वही
लात गुजा से मारा है। एवरीबॉडी क्लाइंब ऑन हर प्रैक्टिकली। So how is your case different from Rahul? This Rahul Nikar ka I think I am rejected.
6463 rejected.
Rejected.
there is no intention to bring the dispute.
What do you mean no intention?
Don't be yesterday.
एक का allowed है, संतोष साहु का allowed है।
He's in custody since
4/6
2026, your worship.
charge sheet submitted?
No,
Not.
your worship.
Or the
Then
letter-
I made it from the-
Then heard the learned counsel appearing on behalf of the parties. Counsel for the petition submits that the petition is in custody since 4/6/2026. And upon inquiry of this court, she submits that charge sheet has not yet been submitted. However, the petition has been falsely implicated in this case. The learned counsel submits that the co-accused, namely Santosh Sahu, has been enlarged on bail in BA number 6407 of 2026. It further transpired during the course of hearing that the bail application of the co-accused, namely Rahul Dicker, has been rejected by this court in BA number 6463 of 2026. The learned counsel for the state has opposed the affair and has submitted that the petitioner is a named accused and the deceased died on account of multiple injuries, including rupture of heart on account of the brutal assault she suffered. After hearing the learned counsel for the parties and considering the fact that the petitioner is named accused and investigation is still going on, and the deceased died on account of the multiple injuries suffered by her, this court is not inclined to enlarge the petitioner on bail. So far as the bail to co-accused, namely Santosh Sao, is concerned, he was granted bail on account of the fact that there was no overt act alleged in the FIR against Santosh Sao. The bail application of the co-accused, namely Rahul Dicker, has been rejected. Case of the petitioner stands on similar footing as that of and this is stage, it is already existed.
Item 7, BA 7042 of 2026.
74, 76 and 8 and the file is at page number 14, the very short FIR notion. May I read you?
Just a minute. FIR is by whom?
By father in law.
Counsel. What is the custody since?
The study since 28/1/2026.
The state is directed to serve notice upon the informant of this case and file counter affidavit on minutes. Let the statement of the victim recorded under section 183 BNSS be called for from the concerned court along with the case diary and its enclosure. He's studying in Tilaiya, right?
Charge has already been framed in
Hold on.
और इसमें देखा जाएगा लॉर्डशिप
Victim का statement देखकर ही आपका bail
इसमें
consider
एक चीज केवल देख लिया जाएगा
अभी क्या देखना है? अभी तो नहीं देखना है।
हाँ ठीक है लॉर्डशिप
जब आप आइएगा तब देखना।
अरेस्ट हो गए थे 26 को
Sorry?
अरेस्ट हो गए थे 26 को एफआईआर 27 को हो रहा है और कस्टडी फिर 28 से हो रहा है
The counter affidavit will be filed by 21st August. Post this case on 25th.
Item 8, BA 7046 of 2026.
in this case the allegation is with respect to murder of 3 persons now let's kindly see the FIR. Yes, we can.
Are you named accused?
Let's name the FIR.
कब
But
से
all-
custody में?
Let's custody is 12/6/2026. Only one ground I will say
I
in my
just want
defense.
to know.
Yes.
Charge sheet submitted.
Let's charge sheet has not been submitted. There's only one ground. If that suffices my case.
Yes.
My lords, the other co-accused persons, they have confessed their guilt. They have said that 3 persons, they killed them. And that is there in the case diary. These persons have got no relation of that. Confessional statement में है कि 3 लोग मिलके मारे हैं. एक बार केवल देख लिया है. केवल एक.
एक बात बताइए, ये इन्वेस्टिगेशन चलते रहता है, इनके पास केस डायरी कैसे आ?
बाकी 3 के ऊपर सेशंस हो गया है. वो 3 जो कन्फेशनल
उन्होंने आपको दे दिया।
सब लोग गांव के हैं. But at the same time, what I humbly submit, my lords, they have already confessed their guilt. उन्होंने कहा कि we were 3 persons and we killed them. These petitioners have got no role assigned in their confessional statement also.
दूसरे के कन्फेशन स्टेटमेंट में कोई भी उसका एक्विटल हुआ है ऐसा?
Acquittal के लिए नहीं बोल रहे हैं.
फिर
my
क्या
lords, I am
हुआ?
only on the ground of bail right now.
नहीं अभी कुछ।
तो एक बार FIR पढ़ देते हैं. If your lordship say,
बहुत अंदर।
ट्रिपल मर्डर है।
ट्रिपल मर्डर है वो।
lords, बात ट्रिपल मर्डर की है ही नहीं.
टाइम और क्या क्या?
However the heinous offense may be, my lords, मेरा ग्राउंड वुड बी दैट मेरे ऊपर क्या है।
आपके
एक
ऊपर
बार
अभी तो इन्वेस्टिगेशन चल ही रहा है, अभी हम कैसे बताएं आपके ऊपर क्या है?
एक बार केवल हम
नहीं, I
part
just
में-
want to know in the case of triple murder, where the investigation is still going on, can I come to a conclusion that there is no evidence against you?
Lords, what I'm saying that as of now, what evidence has come against me?
That's right.
I'm not saying that there is no evidence against me. What I'm trying to
I
say is that what
appreciate-
evidence has come against me. 3 persons who were arrested by the police, they confessed before the police that they have committed the murder.
That's
They have not named me in the confessional statement at all.
Fair
At the
enough.
same time, my lords, उनके निशानदेही पे जो alleged हथियार है वो भी रिकवर हुआ है। तो मेरे ऊपर as of now कुछ है ही
Let's see
नहीं।
that. BA number 7046 of 2026. Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 12/6/2026, and on a query of this court, he has fairly submitted that the charge sheet has not yet been submitted and investigation is going on against the petitioner. However, he submits that 3 co-accused have confessed their guilt before police and there is recovery of the weapon on the basis of their confession statement.
कुल्हाड़ी है रिकवर भी
But they have not taken the name of the petitioners in the involvement of the alleged offense.
3 लोगों का है, तीनों ने नहीं लिया।
बीच में बोलते रहेंगे कुछ नहीं।
I said 3 लोगों का था।
नहीं लिखा है क्या 3 लोगों का? What is this?
Sorry, I said केवल 3 लोगों का confessional
इतना
statement।
irritate मत किया
वही
करो। मतलब
दिखा रहे हैं।
ऑर्डर लिखा रहे बीच में रनिंग कमेंट्री चल रहा है, क्रिकेट मैच है। किस तरह का आप लोग मतलब एडवोकेसी डेवलप कर लिए? आई एम नॉट एबल टू अंडरस्टैंड। कोर्ट ऑर्डर लिखा रहा है, आपको लिखाना, आप लिखाइए अपना सबमिशन, दिखा दीजिए अपना सबमिशन, ही विल टेक इट डाउन। The learned counsel submits that since all the 3 co-accused persons have not taken the name of the petitioner in the commission of the alleged offence, therefore, there is no material against the petitioner. The learned counsel for the state has opposed the prayer for bail and has submitted that the petitioner is a named accused in the FIR and all the 3 members of the family were killed brutally, and there is an allegation under the provisions of section 3/4 of Prevention of Dying Witchcraft Practices Act 2001. After hearing the learned counsel for the parties and considering the fact that investigation against the petitioner is still going on and the petitioner is named accused, and merely because the 3 co-accused persons who are said to have confessed their guilt before police have not taken the name of the petitioner, the same has no bearing in this case. According to the bail application of the
Since the
petitioner,
order
the same
was
has
even
been
dictated, may I say only one thing? FIR में it has been stated that phone call पे किसी ने बताया कि सबने मर्डर किया। There is no direct allegation against me as such. There is no eyewitness.
Item 9, BF 7047 of 2026.
Yes, petitioner.
The petitioner is in custody since 19/4/2026.
You have kidnapped the wife
Yeah.
of the informant, converted her into different religion. This is what you have done. What is this? I don't know. Inter-religion भी है। थोड़ा सा मुश्किल है। क्या चाहते हैं बेल के अलावा ये बताइए? आपका कस्टडी है कब से?
19/4/2026.
चार्जशीट हो गया?
Yes.
क्या स्टेज? चार्जशीट के बाद चार्ज फ्रेम हो गया?
50% हो गया
Please direct allegation. Please. बहस करने के बाद पास ओवर नहीं or the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case. And he is in custody since 19/4/2026. Charge sheet has already been submitted. The learned counsel for the state has opposed the prayer for bail and submits that the petitioner is the main accused in this case, and as per the allegation itself, which was lodged by the husband of the victim, the petitioner had taken away his wife and has been insisting to marry her after converting her into another religion, and the objectionable photograph of the petitioner and the victim has been circulated in social media. Considering the direct allegation made against the petitioner. This court is not inclined to enlarge the petitioner from being constituted.
at this time.
It is always at this stage. Next one.
Item 10, DA.07.08 of 2026.
First, the offence is under section 8 of POSO Act and section 74 of the BS. The entire FIR, the only allegation is that the accused got hold of her hand.
Custody is since
23/5/2026. Charges have been framed.
charge has been framed.
Yes. On 38.
The petitioner is the neighbor of the victim.
Yes. Yes.
The state is directed to serve notice upon the informant of the case. Let the statement of the victim recorded under section 183 BNSS be called for the concerned court, along with the case diary and its enclosures, including the medical examination report of the victim,
She has denied for the medical examination.
if any. The counter affidavit will be filed by 21st. Serve notice and file counter affidavit on merits. Counter affidavit will be filed by 21st, post on 21st.
Item 11, DA.70.55 of 2026.
Offences under section 354, 504, 506 of
सानी आपके जूनियर है? आप बहस करते तो भी नहीं देते, लेकिन आपके जूनियर ने ओपनिंग सेंटेंस में टाइम नहीं मांगा। नहीं, पासओवर बाद में बहस करने के बाद। Am I correct? कोई बात नहीं, नहीं है, अगर ऐसी बात नहीं है। How long have you been practicing? Sorry, 2 years. अगर आपको सीनियर के ग्राउंड में टाइम लेना है, पास ओवर मांगना है, you should say it at the opening sentence. The court might still hear you and grant bail or not grant bail, and then you have the liberty. अगर मिल जाता है तो बड़ी खुशी की बात है, नहीं मिलता है तो सीनियर को सुनते हैं. लेकिन जूनियर अगर बहस करने के बाद पास ओवर मांगे, that is not.
हमको तो अदरवाइज इंस्ट्रक्शन
नहीं, आप कोई भी रहते, हमें तो नहीं पता कौन सीनियर थे इनके, कोई भी रहते, मतलब if the client is here, he should hear it loud and clear. हम बेल नहीं देते, मतलब I am just telling you, थोड़ा सा सीरियस टाइप का एलिगेशन है. It is always at this stage. देखिए इन्वेस्टिगेशन चल ही रहा है ना अभी तो. नहीं, चार्जशीट हो गया, थोड़ा विक्टिम को एग्जामिन हो जाने, लेट द विक्टिम बी एग्जामिन, विक्टिम को एग्जामिन हो जाने. Okay, then you come. Let us see what comes in the evidence of the victim. Never mind. Okay, what's your name?
But the real things should have been communicated to me. Otherwise,
कोई बात नहीं.
May I proceed now? Sorry. The offences alleged under section 354, 506, 504 of the
Nude photographs have been circulated, correct or
No,
not?
let's creating the fake ID. The allegation has been attributed creating the fake ID of
फोन नंबर, फोन किसका था? आपके पिताजी.
हाँ.
उनको एक्यूज बना दे.
The two of the friend have been arraigned as an accused. But when the statement was being recorded, they have denied and they have mother and the victim has refused, only stating that they want the ID to be posted. In Farag,
उन्होंने इसलिए रिफ्यूज कर दिया, शायद उसकी शादी वादी होने वाली थी.
शादी होने वाली थी.
तो क्यों अपना लाइफ बर्बाद करेगी? That is the reason that she did not go for the statement. If the nude photograph have been recovered,
that has not been produced.
आपका
Neither the mother. चार्जशीट
हो चुका है, तो इनसे मंगा लेते हैं.
हाँ, मंगा लिए.
The learned counsel for the petitioner has submitted that although there is an allegation that the nude photograph of the victim was circulated, but no such photograph has been recovered. And charge sheet has been submitted. Petitioner is in custody since 12/5/2026. The learned counsel for the state is directed to seek instructions and file a counter affidavit in this case with particular reference to the submissions made by the learned counsel for the petition. Counter affidavit be filed by 21st, post on 25th. You also serve notice upon the informant.
कितना तारीख को?
25 तारीख को रखें.
22 या 23.
23 तारीख तो संडे आप आ रहे हो उससे?
इसके बाद हम छुट्टी में चल पाते हैं.
तो आपका काउंटर एफिडेविट बी फाइल बाय 19th,
करेक्ट.
पोस्ट ऑन 20th, 20 तारीख को.
हाँ.
Serve notice upon the victim, on the informant.
And the statement of 183 BNSS.
The statement recorded under section 183 BNSS be called for from the concerned court along with the case diary and its enclosures.
Item 12, BA 7057 of 2026.
Yes, petition.
Besides other section, this is the case under section 64(1) of BNSS.
As far as petitioner is concerned, there is no allegation of having committed anything. Only allegation against this petitioner is that her marriage was settled with this petitioner, and she is saying कि हमसे 10,000 रुपया लिया था जो लौटाने के लिए हमको बोला कि आओ, और उसके बाद ले जाके वो क्यों उसके पास ले गया, उसके घर में जो मेरा फेसबुक फ्रेंड है वहां छोड़ के ये चला गया, बाद में he has committed.
This is the क्या बोलना है आपको? The allegation is that the co-accused has committed it. heard the learned counsel's opinion on behalf of the parties. The learned counsel for the petitioner submits that on the face of the allegation made in the FIR by the victim, the marriage between the petitioner and the victim was fixed. And for the purposes of returning certain amount of to the extent of rupees 10,000, the petitioner called the victim, and thereafter the co-accused, namely
Prem
Prem Sharma, committed rape upon her. The learned counsel submits that there is no allegation that the petitioner has committed rape upon the victim. ये फेसबुक फ्रेंड था इसका,
वो जो accused है वो Facebook पर।
co-accused was the कहाँ से FIR में
FIR में।
बताइए कितना
If my lord may kindly have a look to 1, 2, 3, 8 line from below, right side.
okay.
So Prem
The co-accused was the Facebook friend of the victim as per the FIR itself. The petitioner is in custody since
28 to 2026.
28 to 2026. 28/6.
28 to February.
28 to 2026. Charge has been framed.
My lord, as far as charge sheet has been submitted, cognizance taken, and case is committed to the.
The case has been committed to the Court of Sessions. The learned counsel for the state, though has opposed the prayer for bail, but the aforesaid submissions made by the counsel for the petitioner on the face of the FIR lodged by the victim himself is not in dispute. In view of the fact that after hearing the learned counsel for the parties, and in view of the fact that it is the co-accused who happened to be the Facebook friend of the victim against whom there is allegation of rape, the petitioner is entitled to take judgment.
Item 13, BS 7061 of 2026.
What for? What for?
In fact, the grounds of the memo harassment, which is there, that one of the ground which I will raise for the day, in view of the law laid down that on the grounds of arrest has not been supplied to the petitioner, the memo of arrest is going to be.
That तो फिर तो आप अपना ना writ petition फाइल करें.
No, this has been considered for the purpose of bail matter.
For the purposes of.
Well, Supreme Court has considered, therefore I am submitting it.
That's
Well, kindly see only these judgments.
कौन सा allegation है आपके?
Allegation is section 8 and 10 of the POCSO.
8 and 10.
And
कितना punishment है उसमें?
punishment is up to maximum 5 years in section 10.
And 8.
8 maximum 3 years. The allegation
And 9 is also there.
9 and 10, 9 is the definition. The punishment is in 10.
And what about 70?
75
75 of BNS.
75 BNS is also one of the sexual assault, which punishment is 3 years.
75 is just 3 years.
Yes.
And 351?
351 is the criminal intimidation. On the date of occurrence on which it is being said on 26/3/2026, the petitioner was in school which will appear from the biometric attendance. You not kindly see for a moment the annexure 4 page 56. On 26 March 2026, the petitioner was present in the school from 8:49 to 3.
On 26th March.
Yes, that is the allegation on which from the
That is Ram Navami.
Pardon,
It is mentioned Ram Navami.
Ram Navami, in fact, that Ram Navami, that is the reason, previously, can you see my answer 3 page 54? The previously it was Ram Navami Milord on 26th Milord, but the holiday has been shifted to 27th Milord. Therefore, Milord, I have incorporated Milord, Annexure 3 is the order by which Milord the holiday has been shifted Milord, from 26th to 27th. Annexure 3 page 54. 26/3/2026 के स्थान पर 27/3/26 को NI एक्ट के तहत अवकाश घोषित किया गया। Annexure 3 में
So it was a holiday. What is the FIR? You read
FIR.
the FIR.
Yes, Lord, kindly see, Lord. Father has instituted, Lord, so far as FIR is concerned, in which it is being said, Lord, that the daughter of the, Lord, can see page 40 में। दिनांक 26/3/26 को मेरी बेटी तनिषा सोनसो कक्षा 8 में पढ़ती है, अपनी सहेली के साथ प्रिया टुडू, उम्र 14 वर्ष, कक्षा 8 वर्ग में पढ़ती है, जो संजय मिश्रा के घर में पूर्व 1 वर्ष से ट्यूशन जाता था। दिनांक 26/3/26 को 2:30 बजे जब मेरी बेटी के साथ इस तरह से प्राइवेट पार्ट पर टच किया तो अपनी सहेली से दूसरे ने बात कर आदान प्रदान किया तो पता चला कि उसके साथ भी ये सब हरकत टीचर करता है और बहुत सारे स्टूडेंट के साथ भी हुआ है, जो डर के कारण कोई बताया नहीं है। जब मेरी बेटी घर में इस घटना का बात बताई तो हम लोग को पता चला, दोनों बच्चों से बात किया तो दोनों बच्चों रोते हुए आपत्ति बताई। संजय मिश्रा ने हम सभी को डरा धमका कर रखा है और अपने घर में झूठा आरोप देकर बता देने का, इसलिए बच्चों से डरने बताने में हिम्मत नहीं करते। Lord, Annexure 2 can be seen for a moment, Lord. But the mother of the petitioner made an application before the
Yes. The statement of all these persons have been recorded.
No, that has not been done. I have given a specific statement, one of the in spite of
You
the
are in
application.
custody since when?
Since 28th of March 2026.
Charge sheet has been submitted.
Charge has also been framed. I have mentioned in my petition. The mother has made an application, Lord, so for along with the students who were studying in as a tuition, not in tuition, Lord, with the petitioner.
The statement of the victims have been recorded under section 183. At least the daughter.
No, no.
It has not been recorded.
Only the 161 statement is there.
And her statement has not been recorded before the court.
Before the court, already it will not be.
It has been recorded.
Record किया.
It has been recorded.
23. Last page 60, page number 61.
It has been recorded and it has been recorded that she has supported the case.
That maybe not so far as that part is concerned, but the fact remains money so far as this issue is concerned. That is the subject matter of trial first so far as that part is concerned. And secondly, the private receipt, the time of which is being alleged on 26/3/2026 at 2:30. Before that, from the morning at 8:39, the petitioner was in the school till 3 o'clock. That is an admitted position so far as that part is concerned. In spite of the application made by the mother of the petitioner to the superintendent, the police, no, nothing has been investigated on that line. And one more thing, so far as the lots of kindly see the judgment. And recently, you may recollect the Meghalaya issue, in which that I also mentioned. The issue has been decided. This is Mihir Rajesh Shah case. Here in paragraph 8, can you see for the question which was before the Honorable Court. Paragraph 8, whether in each and every case
Even arising out of an offence under the penal code, now BNS would be necessary to furnish grounds of arrest to an accused either before arrest or forthwith after arrest. Well, this was the question which had been put forward. Well, and the question, second question was whether even in exceptional cases where on account of certain exigency it could not be possible to furnish the grounds of arrest, either before arrest or immediately after the arrest would be initiated on the ground of non-compliance with the provision of section 50 CRPC, now section 47 BNSS.
How has it been answered?
Now it has been answered, Lord. I'm not going in the detail, Lord. The conclusion is, Lord, 66 paragraph. The detail has been given, all the circumstances have been dealt with from paragraph 38 onwards, Lord.
So therefore, you see, in case where the ground of arrest
Had not been supplied, my Lord, so far as the petitioner is concerned.
is
The grounds
at the time of arrest,
at the time
was
of
it
arrest.
supplied late? No?
It has not been supplied to me.
Where have you stated?
My Lord, that the supplementary affidavit, the memo of arrest is there, my Lord.
Okay, and thereafter also it was not.
Thereafter
supplied?
also it has not been
Where have
supplied.
you stated?
My Lord, that I have given, it has not been supplied to me, my Lord.
You have just mentioned that
It has not been supplied to me.
no ground of arrest have been prepared, nor it was served to the petitioner.
Yes, my Lord. Therefore, that may be, the state may be asked, my Lord, to reply so far as this issue is concerned. Because that is the constitutional requirement under Article 22, my Lord, and the Honorable Court has observed, my Lord, that it vitiates the arrest and the petitioner is entitled not for liberty to be released. And it is
You were
mandatory.
arrested
On 28th,
28/3/26.
26.
This is applicable for less than 7 years or for all the offences?
All the offences, section 47 and Article 22, my Lord, this is the effect of that part.
A supplementary affidavit has been filed by the petitioner during the court proceedings. आपने स्टेट को सर्व नहीं किया,
Please do copy it.
इसमें नहीं है.
No, just now, madam. Just
After serving a copy to the state council for the state, which is taken on record, the learned counsel submits that the ground of arrest was not communicated to the petitioner, and therefore the arrest itself is vitiated, and the detention of the petitioner is illegal. तब तो बेल बॉन्ड भी नहीं आपको भरना होगा.
no, madam, so far as that part
नहीं
is
तो वही
concerned.
ना, आपको तो बेल आप
The release, my Lord, the release during trial, my Lord, that is not the
no
condition.
you see, तब तो आपको बेल बॉन्ड, फिर आप बेल एप्लीकेशन क्यों फाइल?
नहीं, bail में
एक वो जो होता है,
bail में ही consider होगा वो तो ground this is one
we'll
of
see
the
that.
reasons.
Because I remember जब चार्जशीट विद इन टाइम नहीं जमा होता था, तो बेल एप्लीकेशन नहीं फाइल होता था, हेबियस कॉर्पस फाइल, राइट? हेबियस कॉर्पस होता था,
But in bail
होता था कि नहीं होता था?
नहीं होता था.
WP क्रिमिनल बेल
होता-
एप्लीकेशन नहीं फाइल होता था.
नहीं bail में भी consider होता है.
बेल एप्लीकेशन
वो bail में भी consider होता है. This is an illegality which has been committed and
we'll see
therefore
that.
that can
क्योंकि
be.
अगर आपको बेल देंगे तो बेल बॉन्ड भरने के लिए बोलना पड़ेगा, तो ऑर्डर ही इलीगल हो जाएगा मेरा. Of course.
That I will explain, my Lord, if they will reply that it is not, it is correct then I will explain, my Lord, so far as that part is concerned.
However, the petitioner has filed application seeking bail. The learned counsel for the state is directed to file counter affidavit to the main application and also to the supplementary affidavit filed by the petitioner. Let the notice be served. The state is also directed to serve notice upon the informant of the case. Let the statement of the victim, let the statements recorded before the court under section 183 BNSS be called for from the concerned court, along with the case diary and its enclosures. The counter affidavit will be filed by 21st, post on 27th.
Signed by me. Item 14, DA 7064 of 2026.
Case registered under section 115 to 126 to 109 1, 303 to 352, 351 to 35 of BNS matter. May I read the FIR matter? सेवा में सविनय निवेदन यह है कि बसंती महतो पति मिथिलेश प्रसाद महतो रामपुरी बस्ती थाना बेलमू जिला बोकारो की निवासी हूँ। हम लोगों का को सूचना मिली कि खाता नंबर 131/324 प्लॉट नंबर 3189 कुल रकबा लगभग 5.6 है कि मध्य घोड़ी बस्ती टोला राजा बेड़ा थाना बेलमू जिला बोकारो निवासी महावीर महतो पर पिटिशन मांगा। पिता स्वर्गीय स्वयं के द्वारा मकान निर्माण कार्य किया जा रहा था। यह जमीन हम लोगों का है एवं इस जमीन पर दखल कब्जा हम लोगों का है। इस जमीन को जबरदस्ती निर्माण किया जा रहा है। जब हम लोग वहां जाकर मना किए तो महावीर महतो पिटिशनर के द्वारा पप्पी महतो पिता स्वयं के द्वारा हम लोगों को मारने का आदेश दिया। It is the only allegation against he is the order giver दिया। महावीर महतो के निर्देश पर पप्पी महतो के द्वारा लोहे के रड से हमारी गोतनी सालू देवी पति स्वयं को दाहिने पैर पर मारा, जिससे घायल होकर गिर गए। महावीर महतो के पुत्र दीपक महतो उसकी छाती पर चढ़ गया, जिससे वो बेहोश हो गए। जिसका फायदा उठाकर महावीर महतो की पत्नी द्रौपदी देवी के गले से सोने का चेहरा लगभग 10 ग्राम का होगा, इसे छीन लिया। इसी क्रम में बचाने के लिए मेरी गोतनी चिंता देवी पति स्वयं गए तो महावीर महतो की बेटी उषा कुमारी के द्वारा बांस के डंडे से बाएं हाथ में मारा गया, जिससे हाथ टूट गया। इन लोगों के द्वारा लाठी डंडे से मुझे भी मारा गया, क्योंकि हम लोग सभी महिलाएं थी, इसलिए अपने को बीच बचाव नहीं कर पाए। इसकी सूचना परिवार वाले को मिलने पर आए और हम लोगों को उठाकर अनुमंडल अस्पताल बेरमो ले गए। इलाज के बाद डॉक्टरों के द्वारा there is no specific allegation of assault against this petitioner, my lord. Only allegation against this petitioner, he is the order giver, my lord.
What do you say, madam? Is there any overt act by the petitioner?
No overt act.
No, but you are the instigator, or he is ordered to assault.
Under his instructions it was done.
Yes, sir.
But
There is no there is a land dispute,
there is
admitted
no
land
overt
dispute.
act against the petitioner.
Allegation of it's not there.
Admitted land dispute, my lord. वो खुद कहती हैं कि घर का कंस्ट्रक्शन करे तो उस लैंड पे इसके चलते लड़ाई हुआ। वो ऑलरेडी दोनों के बीच में लैंड डिस्प्यूट चल रहा है।
However, the injuries were found to be grievous.
But no specific allegation of assault against this petitioner.
और the learned counsel से pleading on behalf of the parties. Custody कब से आती है?
13/6/2026।
चार्जशीट तो नहीं हुआ होगा।
चार्जशीट नहीं हुआ।
Or the learned counsel is pleading on behalf of the parties. The learned counsel for the petitioner submits that on the face of the FIR, the only allegation against the petitioner is that the incident had taken place at the instance of the petitioner. The learned counsel submits that there is no overt act alleged against the petitioner, except that upon his instructions, the incident had happened. Yes, further submitted that The FIR itself reveals that there is land dispute between the parties. The learned counsel for the state has opposed the prayer for bail and has submitted that as per the FIR, the construction over the property was being undertaken by the petitioner himself. And the victim suffered grievous injuries. There are two victims who suffered grievous injuries on vital parts of the body. The learned counsel has also submitted that the petitioner also has criminal antecedents.
वो 341 का केस है, उसमें रेस्टेंट का केस है, उसमें कोई ये नहीं
Also
है,
has
रेस्टेंट का
criminal antecedents, which is mentioned in the improved order itself.
वो पीएस केस नंबर 118
And
21
investigation is still going on. After hearing the learned counsel for the parties and considering the allegation in the FIR itself that the incident had taken place at the instance of the petitioner who was undertaking construction work over the property, and the investigation is still going on. In such circumstances, this court is not inclined to enlarge the petitioner on bail at this stage. However, the petitioner may renew his prayer for bail after 6 months.
Renew after 6
months.
Item 15 DA.06.08.2026 of 2026.
Allegation under section 64(2), 3 figures of clause 2, 352 of the MS and also 4 and 6. And
There is SC also.
yes, sir, but the STC is attracted only because the victim is belong to that STC.
That is enough. That is enough to attract SC.
But the thing is, there's a long love relationship also.
From where do I get that?
From the FIR.
The victim has been
Example.
examined.
Yes.
Where is her examination?
PW3.
What is the stage of the case?
You have also
How many witnesses have been examined?
total 4 witnesses have been examined.
4 out of? 4 out of? The charge sheet has been filed under POCSO also.
Yes, sir. You also just
Victim has supported the case, isn't it? She is not hostile, she has supported the case. Okay. How can I help you?
you also you can also see the redemption of victim also in the
Yes,
law
yes.
examination.
See, we are not going
Yes,
to
yes.
examine the cross examination. Yes, tell me.
Can you not see the FIR? FIR itself says that was the love affair. वो कहती है कि हमारा साल भर से प्यार चलता, शादी के रूप में मैटरलाइज नहीं हुआ. Then she has lost the FIR. And this extent she has stated in her deposition. Admittedly दोनों के बीच में लव अफेयर था. पॉक्सो सिर्फ इसलिए लग गया क्योंकि 17 साल 7 महीना के 6 महीना के आसपास.
18 साल से नीचे का तो लव अफेयर भी मना है लॉ में.
यही तो
यही तो मुश्किल है।
पॉक्सो और जुवेनाइल जस्टिस में यही आर्डिनरी है कि 16 साल से ऊपर अगर लड़का एक्यूज है तो टेस्ट होता है कि वो नॉर्मल है कि नहीं, उनका चिल्ड्रन कोर्ट में एज ए मेजर ट्रायल होगा कि नहीं। इसमें सिर्फ 5 महीने के डिफरेंस में ही पॉक्सो लगा। वो बाहर काम करती थी, रांची
ये
आई।
आपका बहस पार्लियामेंट में चलेगा।
I know, my lord. Kindly see
Not-
deposition.
We are looking at the deposition of the
Deposition में वो देखिए लास्ट में कहती है कि she is not author of the FIR. FIR उसका मामा लिखे हैं।
नहीं
Kindly see
आप
paragraph
देखिए ना
24.
वो अपने डिपोजिशन में क्या बोली है।
डिपोजिशन में भी यही कही है कि हमारे साथ प्रेम संबंध था। घटना
पढ़िए ना, पढ़िए तो
घटना फरवरी
पैरा
2000 घटना फरवरी 2025 की है। अभियुक्त रोहित शादी का झांसा देकर मेरे साथ लगातार बनाता था। मेरी मम्मी घर में नहीं रहती थी तब अभियुक्त मेरे घर आके बनाता था और कभी जंगल में ले जाके बनाया। शारीरिक संबंध का विरोध करती थी तो अभियुक्त बोलता था। अप्रैल महीने में दिल्ली काम करने चली थी। जून महीने में मुझे दिल्ली से रांची अभियुक्त ने बुलाया और कुछ दिनों का अपने साथ रखा। दिल्ली से रांची हम फोन किए चले गए, बिना लव अफेयर के आता नहीं। तो मार्च महीने में अभियुक्त ने मुझे जंगल में जाके शादी कर ली। अभियुक्त रोहित कुमार ने मेरे साथ शादी का वीडियो बनाया, लेकिन रोहित कुमार से मना करती थी तो वीडियो वायरल करने की धमकी देते। बट देयर इज नो एविडेंस ऑन दिस। ना ही इसके लिए लेना ये आईटी एक्ट में कोई हमारा चार्ज फ्रेम हो। इट इज जस्ट स्टेटेड। नाउ शादी के बाद रोहित 16 तारीख को गढ़वा, यहाँ से मेरी शादी अभियुक्त रोहित कुमार से 16 तारीख को गढ़वा कोर्ट में था, लेकिन रोहित 11 तारीख को घर से भाग गया।
और the learned counsel appearing on behalf of the parties, the learned counsel for the petition submits that petition
Even
was
a
falsely
deputation.
imputed in this case. And as per the FIR, there was love affair between the petitioner and the victim. He submits that the victim has been examined before the court, and from the perusal of the evidence of the victim also it appears that there was love affair between the petitioner and the victim. How many witnesses have been examined?
3 एक और हुई है अभी हाल में, 4 उसकी मदर हॉस्टाइल हो गई।
Out of how many witnesses? Out of total witnesses?
आउट ऑफ नहीं दिया। इम्प्यून ऑर्डर में लिखा हुआ है कि चार्ज फ्रेम है।
Charge frame में witness कितने हैं? The counsel for the petition is not aware as to how many charge sheet witnesses are there, but he submits that 4 witnesses have been examined in depth. The learned counsel for the state has opposed a prayer for bail and has submitted that victim was minor at the time of the alleged offence, and she has supported the prosecution case in as much as she has stated that the petitioner established relationship with her on the pretext of marriage, and he repeated the same. She has also stated that the victim used to deny, but in spite of that, the petitioner forced himself upon the victim. After hearing the learned counsel for the parties and considering the fact that the victim was minor on the date of the alleged offence and the trial is in progress, this court is not inclined to enlarge the petitioner on bail at this stage. However, the state is directed to ensure that the remaining witnesses are promptly produced before the court. The counsel for the state is directed to communicate this order to the SP of the concerned district and also to the director of prosecution to ensure this.
Permission item 16, BS 3705/2026.
In this case, I have received this report.
Yes, what is the case? The victim also became pregnant.
Yes, my husband. And she had given birth to the girl child.
You are the main assailant. Your sample was also sent for examination. As per the report, the petitioner is not the biological father. देखिए, correct? Stage क्या है केस का?
स्टेट मान लो चार्जशीट सबमिट हो गया 13/11/2025 को, पर अभी तक चार्ज फ्रेम नहीं हुआ है। नेक्स्ट डेट 18/8/2026।
चार्जशीट सबमिट हो गया।
13/11/2025 में।
आप कस्टडी में कब से?
हम कस्टडी में मान लो 13/10/2025।
Charge has not been framed.
नो नहीं मान चार्ज डेट से सिर्फ डेट ज्यादा चार्ज फ्रेम होता है।
ये विक्टिम का स्टेटमेंट जो रिकॉर्ड हुआ था वो आया है?
वन एटी का स्टेटमेंट है हमारे। पहला 27 ऑफ द पेज है।
The learned counsel for the petition submits that the petition is in custody since 13/10/2025 and charge sheet has been submitted on 13/11/25, but charge has not been framed so far. The learned counsel for the state has produced the FSL report in connection with the child born to the victim and the present petitioner. And upon perusal of which it appears that as per the report, the child is not the petitioner is not the biological father of the child. It has been alleged that the petitioner established relationship with the victim and thereafter the victim became pregnant. आपने देख लिया ना जो लिखा है सही? The FSL report which has been produced in sealed cover is returned to the council for the state so that the same and with the direction that the same be immediately forwarded to the court concerned. To this, the counsel for the petitioner submits that the petitioner may be enlightened after hearing the learned counsel for the parties and considering the custody of the petitioner since 13/10/2025 and the aforesaid facts and circumstances, the petitioner is directed to be enlightened.
Item 17 DA.05.08.2026.
Wife dispute between wife and husband. The husband has assaulted wife. Case is under section 109. And this case is fixed for evidence on 19. Both have already compromised the matter with the help of the witness. But it is fixed for evidence on 19 August. I pray that maybe before immediately after 19.
informant has been noticed.
19th को fix बोला है क्या?
Notice has been served upon the informant. 19th के बाद किस दे रखी? उसकी
19
गवाही है।
जी गवाही है 19 इमीडिएट आपका 19
The learned counsel for the petitioner submits that. Victim आके बताएगी ना कि हमको compromise हो गया, हमको कोई डिवाइस।
जी इसीलिए 19th को रख दिया 19th के बाद immediate
The learned counsel for the petitioner submits that the matter be placed after 19th of August as the victim is scheduled to be examined on 19th before the court concerned. At the request of the counsel for the petitioner, close this case on 1st of September. In the meantime, the stage of the case will call for from the concerned court. Sorry? Stage आया तो stage मत मारो.
Item 18 DA.05.08.2026 of 2026.
cyber matter 2 mobile wise recovery 1 victim matter 2 present transaction
आप बताइए क्या बोलना है? One कब से कस्टडी में है?
कस्टडी में 29/4
That हो गया?
जी
What has been recovered?
2 mobile
2 mobile, no SIM,
with SIM
standing in your name.
one Viva my name and second is one Nissan Valencia we also using this
And one victim has been identified.
one victim as per FIR में आया कि
No antecedent.
no payment state has also counted para 9
क्या बोलना है आपको?
मेरी कंप्लेंट है 22 से 1252 1400 रुपये 14,000
14,300
Or the learned counsel submitting on behalf of the parties. The learned counsel for the petitioner submits that two mobile with SIMs are alleged to be recovered from the possession of the petitioner. And the petitioner is in custody since 29/4/2026. Charge sheet has been submitted and has no criminal antecedent. One victim has been identified to the extent of ₹14,000. The learned counsel for the state has opposed the prayer for bail. However, the requested submissions made by the counsel for the petitioner is not in dispute. और कुछ बोलना है आपको? After hearing the learned counsel for the parties and considering the fact that the petitioner has no criminal antecedent and charge sheet has already been submitted, the petitioner is directed to be under trial.
Item 19 BA 5347 of 2026.
Right. Where is it right?
So, may I just know if there is any, I hope there is no foul play. But is there any foul play?
You just have a look. This is what I. What about? What do you mean foul play? Who will play foul?
The husband? No,
You
because
just argue your case.
the whole case is based on that one. Why my bail was rejected, my lord? My
What
bail-
is the allegation? Let us see the allegation.
Yes, let us see the allegation. Let us see the allegation and then the case diary and the reason for rejection.
Let us see what is the allegation against you.
Yes, please.
Read it, please.
Yes. सविनय निवेदन है कि मैं रंजीत कुमार रवानी मदन खटक जिले देवघर का निवासी हूँ। अपनी लड़की खुशबू कुमारी 23 वर्ष का शादी हिंदू रीति रिवाज के अनुसार दिनांक इतना को मंदिर में केशव रवानी निर्सा स्वरूप के साथ किया था। कुछ दिन के बाद मेरे दामाद केशव रवानी मुझे और मेरी बेटी से मोटरसाइकिल का दहेज के रूप में मांग कर रहे थे, परंतु मेरी आर्थिक स्थिति ठीक नहीं होने के कारण मोटरसाइकिल नहीं दे पाई, जिस कारण मेरे दामाद केशव रवानी, रोमन रवानी, कमला देवी, मोमिना देवी, सुचिता देवी, कालू बतानो की धनबाद, बादल रवानी वो पिता और दुबरा देवघर के रहने वाली मेरी बेटी को प्रताड़ित मारपीट करते रहते थे और मोटरसाइकिल की मांग कर रहे थे, जिसका खबर मेरी बेटी मोबाइल पर देती रहती। दिनांक 20/12/2025 को करीब 2-3 बजे बोरियो गांव के एक व्यक्ति द्वारा मेरे मोबाइल पर सूचना दें कि अपनी बेटी मृत्यु हो गई। तब मैं परिवार में कालू बताना आया तो पता चला मेरी बेटी मृत्यु हो गई। अतः थाना प्रभारी मुझे अनुरोध है कि केशव रवानी पति सभी साकिना बोरियो कालू बदन बादल रवानी जिसके विरुद्ध उचित कानूनी कार्रवाई करने की कृपा कीजिए। Now this is the allegation made in
And
the.
since when are you in custody?
I am in custody since 9/2/2026.
इसके पहले कहाँ? इसके पहले did you apply for anticipatory bail exception? Because the incident is of 21/12/25. The FIR is of 21/12/25.
No anticipatory bail was preferred by him. No. If you watch it, goes to the case diary. Now the only allegation against him was that he was a drunk. All the witnesses have consistently stated that it's not a case of dahej. It is not a case of anything with respect to all other people against whom they have made allegation are all innocent. That is why when the bail was being denied, what is the opinion of the court? Why the court is denying my bail? Is at page 17. May I read it? that have considered the rival submission of both produced the report. Material record reveal the specific allegations made against the husband who have subjected the victim to physical and mental torture for demand dowry. There is nothing on record to reveal the death was natural. It was obligatory on the part of the husband to maintain his wife after birth of the child. She died as a result of careless conduct of the petitioner husband. Yes, this has
When
been
was the child born?
2 months, just 2 months. And on the date when the death had occurred, the husband was not in the house. That also the eyewitness who first came to the house, saw her, she was not well, tried to take her to the hospital, but could not succeed because I was not there. All these facts have come in the case diary. And all have consistently stated one fact, that this is not a case of dowry. None have stated that I demanded dowry, or any of the family members, or any of the family members tortured. Yes, she was upset by my drinking habit. This is a fact. Every witness stated that she was upset because of the drinking habit of her husband. And in a dowry death, why these reports were called for was, now we have to ascertain that whether it was a natural death or whether it was death because of some foul play. That is why initially I tried
What
to.
do you say? What do you say?
My lord, 12, my lord, 10, 11, 24, 25, 57, 58. Witnesses have supported, my lord. Prosecution case. Even in place of the class, they deleted, my lord. The statement of the government is also.
But may I read all those paragraphs? First is para 10, that is Abhimanyu Kumar Ramani का बयान.
कहाँ बोला है कि दहेज का मामला?
वो थ्रेटिंग देता था, मैं
लेकिन ऐसा कोई गवाह कुछ बोला है क्या?
दहेज का डायरेक्ट
कोई विटनेस ये बात कहीं पे भी नहीं बोला. ये बोला है कि दारू पीता था और काम नहीं करता था. एक स्वतंत्र साक्षी तो ये कहते हैं कि शादी के बाद शराबी बन जाता है, वही पढ़ देते हैं क्योंकि बहुत.
Heard the learned counsel separating on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is the husband who is in custody since 9/2/2026. The marriage had taken place on 19/6/2024 and FIR was lodged on 21/12/2025 on account of death of the wife of the petitioner. The learned counsel submits that prior to the incident, just 2 months before, a child was born and the cause of death could not be ascertained, although the informant has stated that, in his statement has stated that the petitioner informed the informant that the deceased died by consuming poison. The learned counsel submits that the FSL report was called for. The same has been produced by the Council for the State in State Government. इसमें कोई नहीं है ना जहर का, आप देखें.
What's it?
During the course of hearing, it transpired that no poisoning was found as the cause of death. The learned counsel for the petitioner submits that the cause of death could not be ascertained, and apparently on account of birth of a baby just 2 months before, the deceased died, though in matrimonial home, for unknown reasons. The case is at the stage of, what is
That's
it?
commitment हो गया.
The
Training
case has been committed to the court concerned. The learned counsel for the state has opposed the prayer for bail and submits that there is an allegation of demand of dowry. But he also could not satisfy this court with respect to the cause of death of the deceased. After hearing the learned counsel for the parties, it is apparent that the cause of death could not be ascertained, and the episode report also does not refer to any poisoning of the deceased. And admittedly, a child was born to the deceased just 2 months prior to the date of occurrence. The case has already been committed to the Court of Sessions. In the aforesaid circumstances, the petitioner is directed to be enlarged on bail. The counsel for the state is directed to forward the copy of their present report to the court counsel.
Item 20, DA.05.08.2026.
The counter का direction था during course of test.
बताइए क्या
Yes, Lordship. One mobile phone, Lordship, and two SIM card were recovered.
one mobile and
Two SIM card.
2 SIM. Antecedent?
No antecedent. Only material has come, Lordship, in this case. There is one crime link. And one victim has identified, but they have stated only कि वो फोन किया था तो हमको लगा साइबर फ्रॉड है तो हम कट कर दिए. No money has been transferred.
One attempted.
Attempted, yes. Lordship. Attempted.
Custody of
That 1/5/2026 charge sheet has been.
इन्होंने जो बोला सही बोला. Heard the learned counsel supporting on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 1/5/26, having no criminal antecedent. One mobile, 2 SIM are alleged to have been recovered from the possession of the petitioner. And as per and during investigation, only one crime link was found, and it was an attempt to commit cyber offense. किसी का बेल हुआ. The learned counsel submits that one को accused,
Namely,
Just me.
Jasim Ansari,
Jasim Ansari,
PA number 4915
4915 of
2026.
2026, has been enlarged on bail by coordinate bench of the state. Counsel for the state, though, has opposed the prayer for bail. However, the aforesaid submissions made by the counsel for the petitioner are not in dispute. After hearing the learned counsel for the parties and considering the fact that the petitioner has no criminal antecedent and co-accused has already been enlarged on bail. The petitioner is directed to be enlarged on bail. आप लोग इतना रिलैक्टेंट क्यों रहते हैं co-accused का bail बताने में?
नहीं, हम पहले सोचे अभी बताएंगे।
ऐसा थोड़ी है। अगर कोई कोऑर्डिनेट पेज दिया है उसको पूरा ऑनर करेंगे, आपको क्या लगता है? ऐसा आपको कुछ गलत फहमी?
नहीं,
कभी कभी हम देखते हैं कि केस डायरी नहीं हुआ है तो केस डायरी देख के भेज देते, ऐसा थोड़ी है। और डिस्टिंग्विश करना है तो कर भी देते।
हाँ, तो
ये
ऑर्डर दे दीजिए।
काउंटर है सर।
Counter file during the court proceedings is taken on record. You are under completely wrong notion. ऐसा कोई बात
नहीं।
किसी का भी बेल दिया हुआ रहेगा तो I will certainly honor it. अगर हमको लगेगा डिस्टिंग्विशेबल है तो करेंगे, नहीं तो दे देंगे, ऐसा थोड़ी।
Item 21 DA.05.08 of 2026.
Yes, petition.
This is under section 172.
That has been.
Yes.
Marriage.
Let's say it is not out of the matrimonial dispute. The murder has occurred with confessional statement before accused Mr. Saiba next. There was an affair between the deceased and this gentleman. Which page 15 is the confession statement annexation 2. That will also come in the case study. So, page 15 it starts, and 16 minutes is the relevant portion where it stated that 16 relevant portion.
Then how? Let's read the FIR.
Yes, the FIR has been lodged by the mother of the deceased. Okay. Page 12. मेरा नाम सावित्री देवी सचिन सच रहने वाली हूँ। आज दिनांक 13/12/25 समय करीब 12:30 बजे सचिन सच के समय डर भय दबाव द्वेष और लालच के बिना अपना बयान देती हूँ कि सुमति देवी उम्र 28 वर्ष वाली अपनी बेटी है। सुमति देवी का विवाह वर्ष 2015 में संजय साहु सचिन सच के साथ सिंडेला समिति, इनकी दो बेटी है। करीब 3 वर्ष शादी होने के बाद मेरा दामाद मेरी बेटी से लगातार जाली गलौज मारपीट व प्रताड़ित करने लगा था। इस संबंध में हम दोनों परिवार ने बैठकर समझाने का प्रयास किया था, फिर भी मेरा दामाद मेरी बेटी को प्रताड़ित करते रहा। इसी वर्ष माह अप्रैल में पावरटाट थाना में दोनों के बीच समझौता नहीं हुआ था। मेरी भगिनी कुमुनी देवी के द्वारा समय करीब 7:30 बजे शाम दिनांक 11/12/2025 को फोन से सूचना दिया गया कि मेरी बेटी सुमति देवी जो वर्तमान में कौशल विकास केंद्र सिमडेगा में कार्य प्रदान कर रही है, वह दिनांक 10/12/25 को अपने ससुराल से सिमडेगा मकाम करने सुबह 9 बजे अपनी स्कूटी वाहन से लेकर निकली थी और अभी तक घर वापस नहीं आई है। जिसके बाद हम लोगों ने अपने स्तर से पता लगाने का प्रयास किया पर कुछ पता नहीं चल पाया। उसका मोबाइल डिटेल्स भी बंद उठाया। जब हमने अपने दामाद संजय साहु को फोन किया तो उसके द्वारा फोन नहीं उठाया गया। एक बार उसके भाई मटन साहु द्वारा फोन उठाया गया, ये बताया गया कि संजय साहु फोन चार्ज में लगाकर बाहर निकला हुआ है।
So there is a suspicion raised against you.
Suspicion is there and the confessional statement at paragraph 29, 30 and 31 of the case diary. 29 is the confessional statement. 30 and 31 is the recovery part out of the confessional statement by that Rajesh Sahu that this disease was having an affair. So that the co-accused has confessed that he was having an affair and for some reason he committed the murder, and he also thereafter helped the police in finding out the broken parts of the scene and the things used in the murder of the Plus, another thing is that his husband was living in Goa. Only after the death of the deceased fiancé has come on 13/12/25 he came and he surrendered before the police. That is also coming.
What is there against the petition?
Confessional statement of Rajesh, only there is.
What is there against the petition?
राजेश की कन्फेशन स्टेटमेंट में ही कहा गया है लॉर्डशिप की स्कूटी का नंबर उनके पति के द्वारा ही दिया गया था कि तुम उसका पीछा करोगे, वाइफ का पीछा करोगे। हाँ,
अच्छा, उसको मर्डर भी करो?
नहीं, और मर्डर के जिस दिन मर्डर हुआ उस दिन ही संजय साहु गोवा से अपने गांव आए थे, सेम डे।
So So what involvement is there? स्कूटी का नंबर दिया, पीछा करो, उसके बाद इंस्ट्रक्शन था मर्डर करने.
Instruction में
You see, the co-accused who has committed the murder, there is recovery at the instance of the co-accused. Numerous articles have been recovered. The co-accused का तो ठीक है, लेकिन is there any connivance of the co-accused with the petitioner? लड़ाई झगड़ा होता था, वो तो होता था. इसके अलावा कुछ
petitioner का भी अफेयर था
इसके साथ
गीता कुमारी.
So Geeta Kumari is also an accused in this case? No. कब से custody है?
सर जैसा वो अपने confession statement में भी कहा है कि मेरा अफेयर गीता कुमारी के साथ
अफेयर था, ठीक है.
और हम लोगों का रिलेशन अच्छा नहीं था.
ठीक है, अच्छा रिलेशन नहीं था. क्या अपने कन्फेशन में बोला है कि मैंने मारा या मैंने इंस्ट्रक्शन दिया मारने के लिए? ऐसा तो नहीं है कि नहीं, ये बताइए. कस्टडी में
14/12/25. क्योंकि वो ये बोला था कि तुमको जब वो फोन करके पूछा था कि तुमको जो करना है करो, हमको कोई मतलब नहीं है, क्योंकि वो इन्फॉर्म किया था मैम ने.
Or the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner, though the husband of the deceased was working in Goa, and
अभिषेक को दो बार सेम मंथ में 2 बार आया है गोवा से वापस.
we'll record your submission. अभी इनका submission. The learned counsel submits that the deceased was having some affair with the co-accused, and the co-accused in his confession statement has stated that it was he who killed the deceased, and on his confession statement numerous articles of the deceased were also recovered. The learned counsel submits that he has nowhere stated that the deceased was killed at the instance of her husband, who is the petitioner before us. The learned counsel for the informant has opposed a prayer for bail and has submitted that the petitioner in his confession statement has also stated that he was having a love affair with another lady. And in the confession statement of the co-accused, it has come that the petitioner had given the details of the scooty of the deceased to the co-accused. The learned counsel submits that in short period of time, the petitioner had come from Goa twice, and even on the alleged date of occurrence, the petitioner was present in the village in Simdega. Simdega का है ना? इनका कन्फेशन स्टेटमेंट कहाँ है? Paragraph 22. She has submitted that In the confession statement of the petitioner, it has come that there were fight between the petitioner and the deceased. And the petitioner used to tell the co-accused that he wanted to get rid of his wife. The learned counsel has submitted that the petitioner and the co-accused the co-accused had killed the deceased at the instance of the petitioner. After hearing the learned counsel for the parties, and considering the fact that apart from the confession statement of the petitioner, there appears to be no further material to connect the petitioner with the alleged offense, though it is alleged that, and so far as the co-accused is concerned, on the basis of his confession statement, there has been numerous recoveries. And the petitioner being in custody since 14/12/25. The petitioner is directed to be enlarged on.
Item 22, DA5743 of 2026.
The offense under section of C, the corresponding section is 376(2) and 366. Because page 19 is there, may I permit to read this? निवेदन को साथ सूचित करना है कि मैं सचन सच जिला सचन निवासी हूँ। बचपन से मेरे पति मित्र पसंद मेरी बेटी थाना सचन से पढ़ाई लिखाई एवं अच्छी तरह से परवेश के लिए लड़ने लगी। इसी बीच में मैया में के विपिन तुरी पिता सचन सच गलत नीयत से बाला पूछा कर झांसा देकर 29/5/25 को 4 बजे शाम बेंगलोर लेकर भाग गया। The date is very relevant. 29/5/25 को लेकर भाग गया और दिनांक 28/10/25 को शामी में घर आई आफ्टर 5 months। बताई कि विपिन तुरी बेंगलोर ले गया था। आज मैं उसी के साथ वापस आई हूँ। मेरे साथ काफी मारपीट करता था। मेरी इच्छा के लिए काफी झांसा देकर ये सवाल किया। अभी वह मुझे अपने साथ नहीं रखना चाहता है। इस बात को लेकर मैं पिता संजय तुरी माता पंचम देवी से जाकर सारी बात को बताया। उन दोनों ने गाली गलौज बातें करके वो तारू हो गया। बोले जहाँ जाना है जाओ, हम नहीं रखेंगे। हम लोग अपना सामाजिक रोजगार बचाने का बहुत प्रयास किया, लेकिन वे लोग नहीं माने और गाली गलौज करते हुए मारपीट की। इसी बीच लड़की पेट दर्द की शिकायत बताई। किसी चिकित्सा जांच कराई तो जांच के क्रम में बताया गया कि 3 माह की गर्भवती है। इसके बाद सारी घटना के संबंध में आपसे कानूनी करने के थाना में आवेदन दे देंगे। The date is very important. Occurrence took place on 29/5/2025. Thereafter, she came back to Bangalore 28/10/2025. In the meantime, no complaint has been filed on she. Still, she has not lodged in the FIR. He has lodged the FIR in 26/2/2026. 26/2/26. Now, what happened, Lordship, in the meantime? in the month of November 2025, the daughter of informant got married with some another person, Lordship. And there is dispute between them. And thereafter, she was pregnant of 3 months, and then the FIR has been lodged, Lordship. I am ready to, last occasion, Lordship, there is an order. I am ready to
Ready to what?
DNA के लिए हो जो इसमें ऑर्डर में हो इनका डीएनए सैंपल दिया भी गया जो शादी कहीं और कर ली जब वहां डिस्प्यूट हुआ तो 1 साल पहले का बोल रहे हैं कि हम ले गए थे आए जब 10वां महीना में फिर भी कंप्लेंट नहीं छा
शादी कहाँ हो गई है?
इनकी शादी हो गई दूसरे लड़के
किसके
से
साथ?
ये तो हम नहीं किए लेकिन वेरीफाई भी कर ले रह रहे थे उनके साथ प्रेग्नेंट भी हुए सब चीज वहीं पे हुआ हम एक बार वेरीफाइड है सब कर
नहीं इसमें तो नहीं
कुछ चर्चा भी नहीं की उसका शादी के बारे में चर्चा भी नहीं की हम देख ले रहे हैं नाम है शादी हो गई
उनको नोटिस हुआ है इन्फॉर्मेंट
हम दिए भी स्टेटमेंट भी लिखे
इन्फॉर्मेंट को नोटिस हो गया है कैसे नहीं नोटिस हुआ होगा?
Notice name. Council file notice. Notice name.
You are ready for DNA test?
Yes, Lordship. I'm submitting last occasion sample भी collect
सैंपल कलेक्ट हो चुका है
Notice. आ गया.
रिपोर्ट आ गया
केस डायरी में रिपोर्ट नहीं आया सैंपल कॉपी.
आप मुझे
कब हुआ सैंपल कलेक्ट कब हुआ कलेक्ट कब हुआ डेट बताओ
23/6/26 का डेट है.
23/6/2026
अभी तो रिपोर्ट तैयार भी नहीं हुई
हस्बैंड का नाम हम वेरीफाई कर लेते हैं अगर डायरी मेरे पास है नहीं
आप बताइए कस्टडी आपका कब से
कस्टडी सिंस कस्टडी 30/4/2026
आपका चार्जशीट हुआ All the learned councils appearing on behalf of the parties. The learned council for the petitioner submits that that as per the allegation, the petitioner had taken the victim to Bangalore in the pretext of marriage on 29/5/2025. And ultimately they came back on 28/10/2025 and the victim complained that she was subjected to sexual assault and also violence at the hand of the petitioner. The council submits that the FIR was lodged on 27/2/2026 when the victim was found pregnant. It submits that the sample of the child as well as the petitioner, आपका भी sample लिया गया है. As well as the petitioner has been taken and sent for DNA test, and this has been done recently on 23/6/2026. This fact has also been supported by the Learning Council for the state based on the materials collected in the test. It's, the council for the state submits that the DNA report is awaited and it will take some time. After hearing the learned counsel for the parties and upon going through the statement of the victim, who is minor, recorded under section 183 BNSS, she has made direct allegation against the petitioner. In such circumstances, this court is not inclined to enlarge the petitioner on bail. Hence rejected.
So मेरा एक सजेशन था कि वो
आने में रिपोर्ट आएगा
तो इसको जो एक महीने के लिए
टाइम लगेगा, रिपोर्ट इतना जल्दी नहीं आता। डीएनएस आपको का रिपोर्ट में 6 महीने टाइम लगेगा।
Item 23 BA 5783 of 2026.
ये कुछ तो टाइम 1-2-3 महीने का आफ्टर रिव्यू कुछ भी तो टाइम है।
कोई जरूरी नहीं है आपका बच्चा हो कि किसका बच्चा हो। एलिगेशन है कि आप लेके गए हैं,
एलिगेशन गए तो इनकी तो शादी हो गई है।
शादी हो गई तो एलिगेशन खत्म थोड़ी हो गया। Yes, petitioner.
It's a case of cybercrime from the position of this petitioner.
Custody.
I'm in custody since 8/5/26. Charge sheet already been submitted on 26/7/26. From the position of this petitioner is a recovery of 4 mobile set without SIM card. 4 crime link is there alerts. During the course of investigation, 2 victim has turned up alerts. Amount is 10,000, 7,700. No antecedent, that is written paragraph 92.
4 crime links. Para 42 and 2 victims. Yes, said 4 crime links. Heard the learned counsel appealing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner is in custody since 8/5/26, having no criminal antecedent. The charge sheet has been submitted on 26/7/2026. We submit that 1 mobile without SIM is alleged to have been recovered from the possession of the petitioner, and during investigation, 4 crime link has been found and 2 victims have been identified who are alleged to have been defrauded to the extent of rupees 10,000 and 7,700. The learned counsel for the state has opposed the prayer for bail. However, the appropriate submissions made by the counsel for the petitioner is not in dispute. After hearing the learned counsel for the parties and considering the fact that charge sheet has already been submitted and the petitioner has no criminal antecedent, the petitioner is subject to bail.
Item 24 BA 5789 of 2026. Item 25 BA 5904 of 2026.
Yes, petitioner.
The alleged offenses are under section 64, 72, 79, 302, 352, 352, 355 of the BNS and IK also. It will be proper to read the FIR because I am not reading the FIR. Page 13. लिमिटेड फोटो करना कि मैं सच एंड सच पति के आधार नंबर राजगढ़ जिला से आया हूँ झारखंड के निवासी हूँ। मेरा पति मुंबई में मजदूरी करते हैं और मैं अपने घर में सिलाई सेंटर संचालित कर अपने परिवार का भरण पोषण करते हैं। इसी क्रम में सब 2021 में एक दिन मोहम्मद आसिफ रजा पिता मेरे घर में घुस गया, पिस्तौल से जान मारने के भय दिखाकर जबरन मजबूरन परीक्षा की और साजिश के तहत मेरा असली वीडियो बना लिया और इसी वीडियो को मेरे पति के मोबाइल में देखते हुए सोशल मीडिया में वायरल करने की धमकी दे देकर सन 2021 से 2026
Has the video been recovered? Has the video recovered?
Yes, he has already submitted the video lordship, that is the serial list seized in this case. And one mobile SIM which is alleged in the FIR that belongs to this petitioner that come in time.
अब क्या बताएं?
नहीं, मेरा क्या I am not the person who committed the sexual intercourse with the victim. I am not the person. I am not named in the FIR. In course of investigation.
You are Imran Sheikh.
Yes, I am Imran Sheikh.
इनके मोबाइल सिम से फ्लो किया है।
I am Imran
का एलिगेशन है आसिफ पे लेकिन जो मोबाइल वायरल किया गया है उसमें इनका भी मोबाइल यूज है।
ये नहीं है कि हम यूज किए, इट इज दैट कि आसिफ हैज यूज्ड, इट इज नॉट द केस दैट कि आई हैव यूज्ड, इट इज दैट the आसिफ, two numbers are given that आसिफ has given.
No, how the video of this victim came to your mobile?
Lordship, since it was using by the Asif, not by me myself.
What do you mean? Asif is who? He's your family member.
No, not
Then
family member.
your mobile was lost.
No, that is not the case. Only one paragraph, paragraph 31 of the case diary, paragraph 31 of the case diary, it is said that कि पुलिस अधीक्षक महोदय का अनुसार मोबाइल नंबर 2 मोबाइल का है, इसका जिक्र है 85 एवं 825 का कैश प्राप्त हुआ, दैट इज द कंज्यूमर एप्लीकेशन फॉर्म, जिसके अवलोकन से ज्ञात हुआ कि सदस्य मोबाइल का धारक का नाम इमरान शेख है. दैट इज द ओनली एविडेंस.
So it is your mobile, it is not your mobile. The mobile
No,
has
ये
been
इसी
recovered
में
from whom?
that's not what I have given the Annex 2. Annex 2 the संचार साथी report. सही संचार साथी lordship the my whatever the mobile numbers are in my name, that I have given the details of that. Even if the lordship the impugn order, if lordship sees the impugn order, page 26 in the impugn order.
आसिफ का कोई कन्फेशन स्टेटमेंट है?
नहीं।
आसिफ कस्टडी में आया कि
हाँ अभी आया
मतलब
अभी कुछ दिन पहले आसिफ को सरेंडर किया है, कस्टडी में आ गया. दैट एक्टिव.
आपका चार्जशीट हो गया?
हाँ चार्जशीट हो गया. आईओ को डायरेक्शन था एलिजिबल साहब तभी जब बेल रिजेक्ट किए थे. So far as document of संचार साथी है पर concern, the IO is to look these facts and verify the same so that no innocent person be languished in jail custody. But that regard the IO has not stated anything.
What the learned counsel appearing on behalf of the parties, the learned counsel for the petitioner submits that the petitioner is in custody since 5/5/2026 and charge sheet has already been submitted. The learned counsel submits that as per the allegation in the FIR itself, the alleged offence was committed by the co-accused, namely Asif Raja. And it is, and the petitioner is not named in the FIR.
Not named in
the petitioner is not named in the FIR. The learned counsel for the state, while opposing the prayer for bail, has submitted that the objectionable photograph was made viral, and during investigation it has come that the mobile and SIM was standing in the name of the petitioner. However, the other submissions made by the counsel for the petitioner is not in dispute. The statement of the victim recorded under section 183 BNSS has come, wherein she has made allegation against the co-accused Mohammed Asif Raza, and she has also alleged that Asif Raza has made her objectionable video. So far as the petitioner is concerned, no allegation has been made by the victim. After hearing the learned counsel for the parties and considering the fact that the victim made allegation against Asif Raza, who is said to have sexually exploited her and made her objectionable video, and the charge sheet having already been submitted, the petition is directed to be enlarged on bail.
Item 26, DA.06.08.2026.
Counsel for the state pays for and is granted time till 13th August to comply the last order. Post this case on 18th of August.
Item 27, DT.06.08.2026.
In the case of cyber crime units and the two persons were apprehended by the police, and for the position of this petitioner is a recovery of one mobile set with one SIM card.
Custody,
I'm in custody since 9/5/26.
charge sheet submitted,
Charge sheet submitted on this.
antecedent,
No antecedent, no victim has turned up, there is a victim against the accused person.
these submissions are correct.
कोई केवल antecedent है, no crime link, no victim. वो accused के पास से सारा है.
For the learned counsel's opinion on behalf of the parties, the learned counsel for the petition submits that the petitioner is in custody since 9/5/26. And charge sheet has been submitted. One mobile, one SIM is alleged to have been recovered from the possession of the petitioner. The petitioner has no criminal antecedent and no victim has been identified. The learned counsel submits that all the victims are related to
Co-accused Ajmal
the
Ansari.
co-accused person, namely Azmal Ansari. And you are Sahil Ansari.
Yes, right.
The learned counsel for the state has opposed the prayer for bail, but the aforesaid submissions made by the counsel for the petitioner is not in dispute. After hearing the learned counsel for the parties and considering the fact that charge sheet has been submitted and the petition has no criminal antecedent and no victim is alleged to have been identified connecting the petitioner with the alleged offense, the petition is directed to be last one.
Item 28, DS.06.08.2026. Along with item 29.
काउंटर का डायरेक्शन अगर डायरी आया हुआ कोई विक्टिम नहीं कोई नहीं
So that's the counter.
बाप का है
At the request of the council for the state, the matter is directed to be posted on 18th of August.
अगर डायरी से कहेंगे तो आर्गुमेंट कर देंगे.
देयर इज नो विक्टिम नो क्राइम लिंक कुछ नहीं बाप मदर का सीन है कुछ
Custody का से.
चार्जशीट हो गया है कस्टडी है 8/5/26 से कोई क्राइम लिंक नहीं कोई सीडीआर रिपोर्ट नहीं मदर का सिम है नो एंटीसीडेंट चार्जशीट
What has been recovered?
वन मोबाइल वन सिम दैट इज इन द नेम ऑफ मदर और इनका जो सिम रिकवरी है वो फादर के नंबर कोई क्राइम लिंक नहीं कोई विक्टिम नहीं
बताइए. Yes, state.
और जो सी बी नेम ऑफ अदर्स है
Others मतलब mother's name.
मदर्स इट हैज कम
Any base for crime link?
नहीं नो क्राइम
Any victim?
नो
Or the learned counsel appearing on behalf of the parties, the counsel for the petition submits that the petitioner is in custody since 8/5/2026, having no antecedent,
नो क्रिमिनल
having no criminal antecedent. The
Charge sheet.
charge sheet has been submitted. One mobile, one SIM is alleged to have been recovered from the possession of the petitioner, but neither any crime link has been found nor any victim.
and
has been
SIM is in the
identified.
name of the mother
The SIM is in the name of the mother of the petitioner. The learned counsel for the state has opposed the prayer for bail. However, the aforesaid submissions made by the counsel for the petitioner is not in dispute. After hearing the learned counsel for the parties and considering the fact that charge sheet has been submitted and the petitioner has no criminal antecedent, the petition is directed to be last on.
Same looks with no crime name, no victim.
The petitioner is in custody since
Same
8/5/26. What has been recovered?
one mobile phone.
One mobile, one SIM.
One SIM.
Is alleged to have been recovered from the possession of the petitioner, and the petitioner has no criminal antecedent. No crime link and no victim has been identified. Charge sheet has been submitted. The learned counsel for the state has opposed the prayer for bail. However, the aforesaid submissions made by the counsel for the petitioner are not in dispute. After hearing the learned counsel for the parties and considering the fact that charge sheet has been submitted and the petitioner has no criminal antecedent, the petition is directed to be enlarged on bail.
इनका सी बी के नाम दूसरे
अच्छा.
फादर ने फादर का नाम
इसमें लिखने का जरूरत नहीं.
हाँ नहीं है मतलब
क्राइम लिंक नहीं है तो ठीक है.
Item 30, DS.06.09.08.2026.
FIR merged against unknown person in Russia. इसमें मेडिसिन एफिशिएंट का रिपोर्ट कभी नहीं आ रहा है। कल हुआ है जिसके कन्फेशन पे मेरा नाम आया उनका बेल कल हो गया।
कहाँ से
आपके पास
ऑर्डर नहीं है?
ऑर्डर अपलोड नहीं हुआ है।
इससे पहले भी एक मिनट। Now, this is the case note where Rossi could find not that the affair was against unknown person. The allegation is not the chowkidar was informed and he found a dead body in a sack near the river side. Thereafter, not in course of investigation, on 24th of June 2026, one after another, 4 accused persons were arrested, one after another, and their confessional statements before police were recorded, including the present petitioner. The Lordship may kindly see the case diary is here, wherefrom your Lordship will find my learned and may assist your Lordship to learn. The paragraph of 46, the confessional statement of Mukesh Kumar. So, for this petitioner Anil Kumar is concerned, his confessional statement is recorded in paragraph 42 of the case diary, है ना? और उसके बाद पैरा 53 में वो जो दूसरा जिसका स्विफ्ट कार है उनका है पैरा 53 उनका स्विफ्ट कार जिस कार को यूज किया गया था गुड्डू then पैरा 54 is the seizure of car from Gudu. Para 55 is statement of one Virendra Kumar who happens to be the husband of the lady deceased, and he says that there is suspicion against the accused person Gudu. Then para 67 Dwarika Prasad seizure list witness with regard to the car.
आपके कन्फेशन में क्या?
हमारा कौन से कोई रिकवरी नहीं
इनके
इनके पास से मोबाइल अपना मोबाइल
इंट्रोड्यूस करा
ये
इंट्रोड्यूस कराया था इसको।
ये सस्पिशन ना तो आई विटनेस है ना डायरेक्ट विटनेस है।
एक सेकंड हाँ बताइए क्या बोल
इनका इनका इन पे एलिगेशन ये है कि ये इंट्रोड्यूस कराए थे मेन एक्यूज जो गुड्डू है उसको इंट्रोड्यूस कराए थे डिसीज।
Is there any allegation that they conspired to kill?
No such
Introduce कराए थे।
इंट्रोड्यूस कराए थे और ये मारने में इसका कोई
इनका कोई रिकवरी है कहीं से?
रिकवरी
किसका किसका बेल हुआ से?
बेल हुआ मुकेश कुमार का कल हुआ है। मुकेश कुमार कल हुआ है और दूसरा
गुड्डू का भी बेल हो गया है?
नहीं
गुड्डू का नहीं हुआ है हमको
वो गुड्डू
जहाँ
है
जिसका गाड़ी था उसको हम बेल नहीं
उसका बेल नहीं
किए।
हुआ
तो उसी का डीएनए वाला चल रहा है अभी।
गुड्डू एरिया से अंसारी
और किसको? और
एक
किसको?
गुड्डू
मुकेश
हुआ है विवेक कुमार ये दो आदमी का बोल
और द कस्टडी
24 अप्रैल 2026 ये विवेक कुमार का हम लोग कल वो कौन दिखाए
heard the learned counsels appearing on behalf of the parties. The learned
कोई
counsel
antecedent नहीं
for the petitioner submits that the petitioner has no criminal antecedent and is in custody since 25/4/2026. The charge sheet has already been submitted. He submits that as per the that except confession statement, there is nothing to connect the petitioner from the alleged offence. There is no recovery on the basis of confession statement of the petitioner.
Incriminating article.
Recovery of any incriminating article on the basis of confession statement of the petitioner. The learned counsel has further submitted that, as per the confession statement also, the petitioner had introduced one co-accused, namely Guddu Bandwal, to the deceased. The learned counsel further state, he has further submitted that two co-accused, namely Vivek Kumar and Mukesh Kumar, have been enlarged on bail by this court in BA number 5895 of 2026 by order dated 29/6/2026. And Mukesh Kumar का BA number याद है?
7001 of 2026.
BA number 7001 of
2026
on 4th of August 2026. The learned counsel for the state has opposed the prayer for bail. However, the aforesaid submissions made by the counsel for the petitioner is not in dispute. After hearing the learned counsel for the parties, the charge sheet having been submitted,
Yes.
the two co-accused persons having been enlarged on bail who appear to be similarly situated as that of the petitioner. The petitioner is directed to be.
Item 31, BA 6305 of 2026.
This was may permitted to withdraw because yes, we can
Also for the petitioner seeks permission to withdraw this bail application.
Thank
Permission is accorded, this bail application is discussed. State has no objection.
Thank you. Item 32, BA 6312 of 2026.
Who is for the petitioner? Petitioner absent, post tomorrow.
Item
Day after
33.
tomorrow करिए, कल Thursday है ना? Thursday को नहीं, day after tomorrow, Friday.
Item 33, BA 6317 of 2026.
Petitioner absent, post day after tomorrow.
Item 34, BA 6442 of 2026.
Cases based on section 64 to 10, 69 of Venus Bloods. This is a clear-cut case of consensual relationship between the two adults. And FIR is at case partners. So
Yes.
So मैंने इधर थोड़ा काम है कि मेरे अवंती देवी उम्र 25 वर्ष पिता लेटन भैया ग्राम सचिन वर्ष प्लस 16 ईस्वी में रितेश कुमार पिता जगदीश राम जी से मरिया झगड़ा ने मुझसे शादी का झांसा देकर बात विचार करने लगा। इस बीच मेरी शादी तय हुई, इस बीच में उन्होंने देते हुए शादी दिया। जब मेरे साथ शारीरिक संबंध बनाने लगा जिससे कि मैं गर्भवती हो गई। मैं उससे बोली कि शादी कीजिए तो वह मुझसे बाला फुसला कर रांची ले गया और घर का परेशानी बताते हुए गर्भपात करा दिया। मुझे विश्वास दिलाया कि अगले साल शादी कर लेंगे। 2018 ईस्वी से मुझे रांची में रेंट के रूम में अपने साथ रखने लगा जिससे मैं गर्भवती और रितेश कुमार वाली गोली खिलाता था और शादी के लिए प्रत्येक बार डालते गया। इसी बीच 22 ईस्वी में गर्भवती हो गई। इसके बाद मुझे दिनांक नर्सिंग होम बात करा दिया। उसके बाद में शादी का झांसा देते हुए लगातार संबंध बनाते रहा।
The first incident is postponed.
Yes, sir. And your ladyship, one objection is ladyship. That was not a valid consent, your ladyship. As because as per the Aadhaar card, her date of birth is 2001, your ladyship, and the first incident took place in 2016, your ladyship. That is the subject of trial, your ladyship. But the factual allegations on the FIR specifically says that she was a minor at that time, and at the time of the first abortion, also, your ladyship, she was a
Charge
minor.
has been framed under which section? Charge has been framed under which section? Since when are you in custody?
I'm in custody since 3/5/26.
Charge
Charge
sheet
submitted.
submitted.
Charge sheet submitted.
Under which section?
I'm not aware.
Case 2026. Case 2026. Section 64 to M89 and BNS 46812 also Act.
Or the learned counsels
At that
appearing
point
on
of time,
behalf of
alerts,
the
the
parties.
FIR has not been registered.
Just
And there's a
only one
delay of
objection.
10 years in lodging the FIR minutes.
One objection that she was minor, your ladyship. At the
that
time
point
of
time,
abortion,
at that
also
point
she
of
was
time,
minor.
She has not filed any case.
Victim का evidence कराइए उसके बाद आते हैं. Heard the learned counsel, depending upon what she does. Heard the learned counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. And as per the FIR, which has been lodged on 11/3/2026, the initial sexual assault was committed way back in 2016. The learned counsel submits that it is a clear case of love affair between the petitioner and the victim, and the victim has been insisting upon marriage, but the petitioner having refused to marry, the FIR has been lodged. The learned counsel for the informant has opposed the prayer for bail and has submitted that the initial incident was a case of forceful sexual assault. The learned counsel for the state,
Your Ladyship, that there was no valid consent.
forceful sexual assault काफी नहीं है.
Apologies.
The learned counsel for the state has opposed the prayer for bail and has submitted that charge sheet has been submitted under section
64(2)(m),
64(2)(m), 89 BNS and section 4 and 6 of the POCSO Act.
4, 6, 8, 12.
4, 6, 8 and 12 of the POCSO Act. After hearing the learned counsel for the parties and considering the fact that there is direct allegation against the petitioner, and charge sheet has also been submitted under POCSO Act. This court is not inclined to enlarge the petitioner on bail constituted.
Item 25, BA 6458 of 2026.
My lordship, इसमें informant साइज से मुकाबला मिला है जो कल फाइल
नाम बताइए अपना.
राहुल कुमार.
Mr. Rahul Kumar, advocate, is on raised for and is permitted to file wakalat during the course of the course is listed. Tomorrow and India after tomorrow.
Item 36, BA 6490 of 2026.
I am opinion on behalf of the government. In this case, lordship, not the one.
183 का statement आया हुआ है.
Lord, I am filing.
You are filing wakalat.
Counter.
Counter. You have served in the following.
Yes, sir. They, I have served the court.
आपने 183 का statement लगाया है.
नहीं, 183 का हमारे पास नहीं.
क्या नाम है?
That is
विकास.
पूजा.
Just a minute.
हम लोग को नहीं मिलता है.
There is absolutely direct allegation of
Lordship, may I submit? If your lordship allow me to submit.
Yes, yes. You are most welcome to submit. But I just 183 का statement पढ़े तो आपको बताएं. क्या बोले कि आपको मिलता नहीं.
नहीं, हम लोग को आजकल नहीं मिलता.
बताइए.
In this case, lordship, what happened? That the lady is an informant. Is a constable of CISF. Enough major, and it is her case that they are in relation last 5 years. When my marriage has been solemnized, thereafter these criminal cases are started. Though only.
When were you married?
I am married in 2023. My wife also given annexure too, that he is also represented before SP and the officer in charge, that these things are going on.
Why will she falsely implicate you? She is a constable in CIS.
Yes,
quite
lordship.
well placed. Quite well placed. Why will she falsely implicate you?
Lordship, that till last 5 years when they are in relation, and when my marriage has been solemnized, then I back out from that relation, and therefore this cases has been, and she is a major enough. She is posted at Lordship BCCL. When she was posted at Bokaro Steel plant, our relations are developed, and thereafter she went there.
She's also married.
She is also married.
She's also married. You see, if there is a relationship and both are married, so there is no question of making further allegation against each other. She has also stated that
She's
you
not
went to
living-
her school and then talked to her
She is
son.
not living with her husband. And this has the 168 that statement. She has not stated anything regarding the sexually harassment.
No,
that-
she has 164 statement she has made.
160, but she has not stated in first information report. She would have been stated in first information report firstly. That means it is afterthought. If you, not a single word has been whispered regarding the sexual harassment in first information report. She has not uttered, not a single word. Therefore, Lordship, later on, the 69 and 64 one has been added in first information report. First page of the first information report, my lord may kindly see.
ये क्या लिखिए, मेरा विवाह दिनांक 9/12/23 को विकास कुमार सिंह के साथ हुआ. विकास कुमार सिंह is the petitioner
Look the page.
in the FIR.
FIR,
In page number 27.
she is a divorcee. She is not living with her own actual husband.
ये 9/12/23 को विकास कुमार सिंह के साथ हुआ. ये क्यों लिखे?
Page 27.
Page 25 में देखिए. 25.
That is my wife now.
Oh, your wife.
It
Now,
is,
boy, I'm so ashamed of
Annexure 2, that is my wife has represented before the.
Okay.
Annexure 1 is page 6, starts from page 16. उसे मेरी 5 वर्ष पूर्व लगभग पहचान हुई थी. उस समय से उससे बातचीत होती थी, उसे स्वयं सो
Yes, in the FIR there is no allegation of sexual
no
assault.
allegation.
Look, the Lordship may kindly see. Now the charge sheet has been submitted in that section.
That's right, might
Yes.
have been, but why no allegation in the FIR? Expression.
Lord, the scene
She
especially
is the
says
informant of the case. She has not made any allegation of any sexual assault. And in the 183 statement, she is making so many allegations.
Lord, the actual
Date
fact
to
is,
kindly seen that 130, 180.
Lord, the actual fact is that is, Lord, the Lordship may kindly allow me to.
Charge sheet has been submitted.
Yes.
Charge sheet has been submitted. Lord, now, Lord, I will place Lord the case diary. The fact is, Lord, if Lordship may kindly see. Right from paragraph 9, I would like to place. My Lordship,
Yes.
okay. Paragraph 9, if Lordship may kindly see. The independent witness. The statement of the independent. The case is something else. Under the pressure, on the basis of the threat, the petitioner established sexual relation with the victim, knowing fully well, she is placed in the CISF and she is a earning lady. Now, several times, I will come later on. Now, paragraph 9. घटनास्थल पर तरुण मारुति स्पेयर दुकान का मालिक तरुण कुमार सचिन सच का बयान लेने पर बताया कि दिनांक 23/4/2026. So why the FIR has been lodged on thereafter? 23/4/2026 को इनके दुकान पर करीब इतना बजे के बीच एक मैडम पूजा कुमारी अपने टाटा कर्व कार में म्यूजिक सिस्टम लगवाने के लिए आई.
उसके कुछ देर बाद वहां पर विकास कुमार सिंह जो सूरज ट्रांसपोर्ट चास में काम करता है, वह अपने बेलूनों कार से पहुंचा और उनसे पूछा कि कार में क्या क्या काम हो रहा है और काम कौन करवा रहा है। उन्होंने जवाब दिया कि एक मैडम आई थी और वो म्यूजिक सिस्टम लगवा रही है। उसके बाद वह वहां पर घूम घूम कर मतलब टेकिंग द नेम ऑफ विक्टिम, लड़की का नाम लेकर अश्लील गाली देने लगा। तब तक मैडम भी आ गई तो उनसे गाली देने लगा और बहुत तरह का बात करके उनको धमकाने लगा। इसी बीच
ये
मैडम
सारी चीजें सही है, लेकिन इस तरह का कोई एलिगेशन नहीं है ना एफआईआर में भी। And in the 183 statement, she is making allegation of sexual assaults.
The sexual assault, that has I have mentioned in my counter affidavit. The sometime it happened, the where she says कि हमारा 5 साल से जान पहचान था and this has been happened subsequently. In the statement recorded before the magistrate, she made a especially allegation against that. Because earlier, she was under immense pressure,
What? Whose pressure?
Because
CISF constable.
Lordship में can you see the
Whose pressure?
evidence of the independent witnesses,
Para 9 I have seen.
Yes,
Because there is no allegation of any kind of assault.
So far as the abusing, subsequently
Abuse is there.
Subsequently, a person, openly, he is,
Just see.
She is the informant.
Yes.
Okay, I please come. Sorry. नहीं सॉरी बोलने का जरूरत है, इसका जरा इनका ऑनलाइन बंद कर